What happens when the Constitution of India goes silent? What happens when citizens are arrested and the courts say they cannot even ask why? Today I am speaking about one of the most controversial judgments in the India's constitutional history, that is the ADM Jabalpur case, also known as the habeas corpus case. Let's go back to 1975. On 25th of June 1975, Prime Minister Indira Gandhi declared a national emergency under Article 352 of the India's Constitution. Civil liberties were suspended, political opponents were detained, press freedom was restricted, and under Article 359 of the India's Constitution, the government suspended the rights of citizens to approach courts for the enforcement of the fundamental rights, including the Article 21 of the Constitution, that is the right to life and personal liberty. Thousands were arrested under preventive detention laws, and many of them filed habeas corpus petitions in the high courts. They argued that even during emergency, if detention is illegal, courts must intervene. Some high courts agreed, but the government appealed to the Supreme Court. The main question before the Supreme Court was simple but powerful. If Article 21 is suspended during the emergency, can a detained person approach the court to challenge unlawful detention? In other words, does the right to life completely disappear during emergency? In 1976, the Supreme Court of India delivered its judgment by a 4:1 majority. The court held that is no. But when the right to enforce Article 21 is suspended, no person can file a habeas corpus petition. The majority judges were the Chief Justice of India A.N. Roy, M.H. Beg, Y.V. Chandrachud, and P.N. Bhagwati. The court essentially said that during emergency, even if the detention is illegal, courts cannot provide relief. This meant the personal liberty depends entirely on the will of the executive. But there was one powerful dissent. Justice H.R. Khanna stood alone. He said something extraordinary. He stated that the right to life and personal liberty is not a gift of the Indian Constitution. It is an inherent in every human being. Even if Article 21 is suspended, the state has no power to deprive a person of life or liberty without the authority of law. His dissent cost him the position of Chief Justice, but history remembers him as the guardian of the liberty. And years later, the Supreme Court in itself acknowledged that the ADM Jabalpur judgment was wrong. In 2017, in the landmark privacy judgment by the Justice K.S. Puttaswamy versus Union of India, the court explicitly overruled the ADM Jabalpur case. The court restored that the central importance of Article 21 and affirmed that the right to life and personal liberty cannot be extinguished even during crisis. ADM Jabalpur is not just a case from history. It is a reminder that constitutional rights are tested most during the emergencies, a reminder that judicial independence is the backbone of the democracy, and a reminder that sometimes a single dissent can shape the future of the nation. And thank you.